jury instruction. Page 5, what is aggravated robbery? Well, there's the instruction for aggravated robbery. Page 6, definitions for murder, perpetration, and aggravated robbery. The definitions there are the intent is to commit the robbery, not the intent to kill. So it's just killing, unlawful killing during the robbery. So it's a different intent than what there is for murder, for premeditated and for second degree murder. It's a different intent. Because in first degree murder, you have to intend to cause the death. In the robbery, all you intend to do is rob and then someone dies. Okay, so counts, page 7, we have second degree murder, voluntary manslaughter. The distinction between the two. Reckless homicide, criminally negligent homicide, as you requested, Mr. Massey. And the definitions for count 1, for the lessers of count 1, I delineate because it's different, knowing, different intention, because it's knowingly cause the death or intentionally cause the death of the alleged victim. Recklessly, criminally negligence. And let's see, that's page 9. Page 10, first degree murder. What I did was I eliminated having to go through this 4 times. I eliminated one of them because count 2 and count 3 are identical. Count 4 is different only in the respect that it involves the fetus. So I gave the definition again for count 4. So on count 2 and 3, just the first degree murder. And then someone complained that they didn't see premeditated in there and they were correct. Now it's in there on bottom page 10, okay? What a premeditated act is, okay? Page 11, second degree murder, involuntary manslaughter, reckless homicide, criminally negligent homicide. Definitions for counts 2, 3, and 4, because these definitions apply to all 3 of those counts. So that's on page 12 and 13. Page 14 is the, like I was saying, it's slightly different because it involves an embryo. That's the only difference. But I elected to go ahead and charge again with murder first degree, second degree, voluntary manslaughter, reckless homicide, criminally negligent homicide, page 16. All that is pretty repetitious. Then on page 17 is the standard stuff. Presumption of innocence, burden of proof, reasonable doubt, impeaching a witness. And then on the next page we have prior consistent statement that I've already read to them after the phone call. Also evidence direct and circumstantial, credibility of a witness on page 19, and defendant not testifying. The sample I gave you all had both. We took that out, so on page 19 is defendant not testifying. And let's see, page 20, expert witness in identity, the identity have it be proved, and of course Shelby Isaac's name is in there, and all that has to be proved beyond a reasonable doubt. 21, confession or admission against interest. It could be either one. I left it both ways. It just depends upon how they want to treat this C's statement, which could be argued both ways as either a confession or statement against interest, if they choose to believe it.
Because I'm just saying, talking about
what she said. Right. It is a statement, and it is considered at least a statement against interest, and can be argued it was a statement of admission. So it's there for their consideration. Accomplice, and I have accomplice in there.
Judge, we have thought about this charge overnight, and I know Your Honor talked about it a great deal yesterday, but considering the proof and the testimony of all the witnesses, we find that there's no evidence that Victoria Say was an accomplice in this murder.
Well, I think it's a jury question. I know we talked about it. I mean, because the very first line saying an accomplice is a person knowingly, voluntarily, with common intent with the principal offender unites with him or her in the commission of the crime. I'm just making a jump here. I'm making an assumption that the defense is going to be saying that we didn't have common intent with anyone, that this C was probably the perpetrator, what could be argued. So, but anyway, the proof that came from Miss C is that she brought her there and she took her away. So the jury can determine whether they think she's an accomplice or not. I think it has been in the record that she was charged with accessory after the fact. Now, I don't believe that merely being charged with accessory after the fact would make you an accomplice, because that wouldn't mean necessarily that you knowingly, voluntarily, and with common intent united with them in the commission of crime. So, it's a unanimous verdict on page 22, deliberation, multiple counts, finding on each required, and then it's just a standard things that are normally read for each count. So, and I have a jury form for each. I've modified the form, so the form that you have forms on your last 3 or 4 pages? 34, 35?
Yeah.
Yes, Judge.
Rather than have a blank where they fill in the blank, I'm just going to have the 4 lessers in the order they're be considered, and they can check one of those boxes for the lessers, so they don't have to fill in anything. But you'll see the form before we give it to them. Yeah. All right, any questions?
Let me speak with Ms. Cheeks 1 second about the defendant not testifying.
All right, because what we need to do is, we're going to, the secretary is waiting. We have a fast copier, so we can make copies for the jury really quick. It'll only take about 5 minutes to make copies. So let me know if y'all see any changes needed. Okay? Now, what I was getting to there, I had the original here. You are not to write on my original copy. It will go back there with you as well. And that would be considered the official charge. You have a copy of it. Now, the law says this has to be read into the record. I just can't give you a copy of it. Let the attorneys start their closing arguments and refer to the pages. I'm not sure exactly why that has to be read into the record. I guess so that they're sure that everyone has heard it at least once. Okay. I guess it might go back to a time when people really weren't very good at reading. I don't know. But anyway, so it has to be read into the record. It takes about 35 to 40 minutes to read it in the record. So I may take a water break every now and then to see if my voice will hang up and it will hold up. Now, if you notice on the first page, there are what we call lesser included offenses. And so as not to be confused, there's 4 counts of this indictment, and each charge murder first degree. And the law in the state of Tennessee says that lesser included offenses shall be charged to the jury for your consideration. Okay? Now, you only go to the lesser included offense unless you find the defendant not guilty of the charged offense. And this is pretty self-explanatory. I like to give an example that has nothing to do with the law as to how this works. Lesser included offenses are kind of like a recipe. The original charge being a recipe, certain elements that have to be proven. If you take away one of those elements, then you'll end up with something less. It's kind of like you have pineapple upside down cake, for instance. You go to the store and you buy your ingredients and you come home and you start to make your cake. And then you find out that technically you left pineapple at the store. Well, you got the cake already, you pop it in the oven, but not going to be pineapple and elm cake. You take one of those elements, one of those ingredients away, and you have something lesser, and it's lesser than what you started, and therefore we have something else. Now, eventually, if you keep taking elements away, then of course that would be synonymous in law to not guilty. Okay. Now, I do also have to apologize for some things. You'll hear some repetition, and you'll also hear some legalese. Now, these instructions are a group of lawyers and judges' best attempt to put the legal terms into non-legal language. We do the best we can, but we're not infallible. Okay, so you'll know the legalese when you see it. Okay, just a warning. So, members of the jury, this indictment is in 4 counts. Count 1 of this indictment charges the defendant with the offense of first-degree murder and the perpetration of aggravated robbery. This offense embraces and includes the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Count 2 in this indictment charges the defendant with the offense of first-degree murder. The offense embraces and includes the lesser offenses of second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Count 3 of this indictment charges the defendant with first-degree murder. The offense embraces and includes the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Count 4 of this indictment charges the defendant with the offense of first-degree murder. This offense embraces and includes the lesser included offenses of second-degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. You will consider each lesser included offense only after you unanimously find the defendant not guilty of the greater offense in the order presented. The law makes it a duty of the court to give in charge to the jury the law relative to the case on trial, and the duty of the jury to carefully consider all the evidence delivered to them in the trial and under the law given them by the court, render their verdict with absolute impartiality. The jury are the sole judges of the facts, and of the law as applies to the facts of the case. In making up your verdict, you are to consider the law in connection with the facts, but the court is the proper source in which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. No sympathy, no prejudice. You can have no sympathy or prejudice or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice should dictate. Notes. Members of the jury have been allowed to take notes in this case. The court charges you that these notes are for your individual use only, and you should not use said notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of said notes. They should not be shown to others, nor prepared, nor referred to in any way as authority, but should be used privately only by the maker said notes as an aid to his or her individual memory. Indictment. The indictment in this case is a formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. Times during the trial are ruled upon admissibility of evidence. You must not concern yourself with these rulings, neither by such rulings, these instructions, or any other remarks which I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Statements, arguments, or remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. Any statements were made that you believe are not supported by the evidence, you should disregard them. Whenever the word he is used in these instructions, you may consider it as applying equally to a woman or an entity such as a corporation. The evidence in this case has been completed, and the arguments are soon to follow. Now it is my duty to instruct you as to the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The order in which these instructions are given is not an indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding the case. You should consider all of the evidence in light of your own observations and experience in life. The court will now explain to you the law applicable to count one charged in this indictment. First-degree murder, killing and perpetration of aggravated robbery. Any person who commits first-degree murder is guilty of the crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed A.D. Tate. 2, that the killing was committed. The perpetration or the intent to perpetrate the alleged aggravated robbery, that is, the killing was closely connected to the alleged aggravated robbery, was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged aggravated robbery. The intent to commit the underlying felony must exist prior to or concurrent with commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated robbery. The killing may proceed, coincide with, or follow the aggravated robbery and still be considered as occurring in the perpetration of the aggravated robbery, so long as there is a connection in time, place, and continuity of action. The elements necessary to constitute aggravated robbery are aggravated robbery. Any person who commits the offense of aggravated robbery is guilty of the crime. To define a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant knowingly obtained or exercised control over property owned by A.D. Tate. And 2, that the defendant did not have the owner's effective consent. And 3, that the defendant intended to deprive the owner of the property. And 4, that the defendant took such property from person to another by the use of violence or by putting the person in fear. 5, that the defendant took such property intentionally or knowingly. And 6, that the defendant accomplished this act with a deadly weapon or by display of any article used or fashioned to leave the alleged victim or reasonably believed to be a deadly weapon. The fear constituting an element of any robbery is fear of present personal peril or violence offered or intended. Resistance of the party robbed is not required. The taking from the person may be actual or constructed. It is actual when the taking is immediately from the person, and constructed when in the possession of the person or in the person's presence. The alleged fear or violence used in the taking of the property must precede, accompany, or occur at the same time as the taking to constitute an element of robbery. Definitions: murder, perpetration of aggravated robbery. Obtain means to bring about a transfer or purported transfer of property or of a legally recognized interest therein, whether to the defendant or another. Obtain includes, but is not limited to, the taking, carrying away, or the sale, conveyance, or transfer of title to, or interest in, or possession of property. Exercise control over property is defined as a right to direct how property, real or personal, shall be used or disposed. Generally, one must possess the right of possession in property in order to exercise control over it. Such possession may be actual or constructive, sole or joint. Also, one may have the right to control property without having a possessory interest. In such instances, if the defendant takes some action with the intent to deprive the owner of the property, and the defendant did so knowingly, without the owner's effective consent, the jury would be justified in returning a verdict of guilty. Anyone who is in a position to take some action that deprives the owner of property is in a position to exercise control. Property means anything of value, including but not limited to money, tangible or intangible personal property. Owner means a person other than the defendant who has possession of or any interest other than a mortgage, deed of trust, or security interest of property, even though that possession or interest is unlawful. Without whose consent, the defendant has no authority to exert property. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act or another. Deprive means to withhold property from the owner permanently, or for such period of time as to substantially diminish the value or enjoyment of the property to the owner. Bodily injury includes the cut, abrasion, bruise, burn, or disfigurement of physical pain, or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is a person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Violence means evidence of physical force unlawfully exercised so as to damage, injure, or abuse. Physical contact is not required to prove violence. Unlawfully pointing a deadly weapon at an alleged victim is physical force directed toward the body of the victim. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must prove, beyond a reasonable doubt, the existence of the following essential elements. One, that the defendant unlawfully killed, ADT, and that the defendant acted knowingly. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven, beyond a reasonable doubt, the existence of the following essential elements. One, that the defendant unlawfully killed ADT, and two, that the defendant acted intentionally and knowingly, and three, that the killing resulted from a state of passion produced by adequate provocation of the alleged victim sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result in a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, the defendant killed the alleged victim, and two, the defendant acted recklessly. Criminally negligent homicide. Any person who commits the offense of criminally negligent homicide is guilty of the crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant's conduct resulted in the death of the alleged victim. And two, that the defendant acted with criminal negligence. Definitions, less of the plan one. Excuse me. Knowingly means that a person acts with an awareness that their conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established when it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is a person's conscious objective or desire to cause the death of the alleged victim. Recklessly means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established when it is shown that the defendant acted intentionally or knowingly. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. If you find beyond a reasonable doubt the defendant was criminally negligent, you must also find the death of the alleged victim was a proximate result of the defendant's criminal negligence. The court will now explain to you the law applicable to count 2 and 3 charges in this case. First degree murder, premeditated killing. Any person who commits the offense of first degree murder is guilty of the crime. For you to find the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. 2, the defendant acted intentionally. The person acts intentionally when his person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result of the death of a person, and that she did so with premeditation when the killing of another, even not the intended victim, would be first degree murder. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found in the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder, knowing killing of another, any person who commits second-degree murder is guilty of the crime. For you to find the defendant guilty of this offense, the state must be proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And 2, that the defendant acted knowingly. Voluntary manslaughter, or any person who commits voluntary manslaughter is guilty of the crime. For you to find the defendant guilty of this offense, the state must be proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And 2, that the defendant acted intentionally or knowingly. And 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a rational manner. Again, the stakes between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a rational manner. Reckless homicide, any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must be proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant killed the alleged victim. And 2, that the defendant acted recklessly. Criminally negligent homicide. Any person who commits the offense of criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must be proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant's conduct resulted in the death of the alleged victim, and 2, the defendant acted with criminal negligence. Definitions for counts 2, 3, and 4. Knowingly means that a person acts with an awareness that her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is a person's conscious objective or desire to cause the death of the alleged victim. Recklessly means the person acts recklessly when the person is aware of, consciously disregards the substantial and justifiable risk that the alleged victim will be killed. Risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown that the defendant acted intentionally or knowingly. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. If you find beyond reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was a proximate result of the defendant's criminal negligence. The court will now explain to you law applicable to count 4 charged in this indictment: first-degree murder, premeditated killing. Any person who commits the offense of first-degree murder is guilty of a crime. If you define the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the unborn child of Edwina Thomas, and that the defendant acted intentionally. A person acts intentionally when a person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result of the death of a person, and that she did so with premeditation, the killing of another, even not the intended victim, would be first-degree murder, and that the killing was premeditated. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. The premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time she allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found in the decision to kill is first formed during the heat of passion. The accused commits the act of the passion after the passion has been. Second-degree murder, knowing killing of another. Any person who commits second-degree murder is guilty of crime. If you define the defendant guilty of this offense, the state must prove beyond a reasonable doubt the existence of the following essential elements: that the defendant, 1, that the defendant unlawfully killed unborn child of Edwina Thomas, and 2, the defendant acted knowingly. Any alleged victim includes a human embryo or fetus at any stage of gestation in utero. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of the crime. If you define the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant unlawfully killed the unborn child of Edwina Thomas, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in a rational manner. Any alleged victim includes a human embryo or fetus at any stage of gestation in the utero. Again, the distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation of the alleged victim sufficient to lead a reasonable person to act in a rational manner. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of the crime. If you define the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant killed the alleged victim, and 2, that the defendant acted recklessly. Criminally negligent homicide. Any person who commits the offense of criminally negligent homicide is guilty of the crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant's conduct resulted in the death of the alleged victim, and 2, that the defendant acted with criminal negligence. Presumption of innocence. You enter upon this investigation with a presumption that the defendant is not guilty of any crime, and this presumption stands as a witness for her unless it is rebutted and overturned by competent and credible proof. It is therefore incumbent upon the state, before you can convict the defendant, to establish to your satisfaction, beyond a reasonable doubt, that the crime charged in the indictment has been committed, that the same was committed before the finding of this indictment, and that the defendant at the bar committed the crime in such manner that would make her guilty under the law heretofore defined and explained to you. Burden of proof. The state has burden of proving the guilt of the defendant beyond a reasonable doubt. And this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove her innocence. Reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof of the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. This certainty is required as to every element proved necessary to constitute the offense. Impeaching a witness. A witness may be impeached by proving that a witness has made some material statements out of court that are at variance with the witness's evidence on the witness stand. Generally, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility, and not as substantive evidence of the truth of matter asserted in such out-of-court statements. However, if the prior inconsistent statement of the testifying witness is a written statement signed by the witness, or is an audio or video recorded statement, or is a statement given under oath, then proof of such prior inconsistent statement may be considered by you as substantive evidence of the truth of the matter asserted in such prior out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When the witness is thus impeached, the jury has a right to disregard the witness's evidence and treat it as untrue, except where it is corroborated by the credible testimony or by the facts and circumstances proved on the trial. Prior consistent statement. The witness's credibility is attacked by a suggestion that the witness's testimony is fabricated or is a deliberate falsehood. A prior consistent statement may be introduced for the sole purpose of corroborating the witness's testimony. Prior consistent statements may not be admitted as substantive evidence of the truth of the matter asserted in such statements and are admissible only to rehabilitate the witness's credibility. You are the sole judges of what weight should be given to such statement for rehabilitative purposes. Evidence. One type of evidence is called direct evidence, the other called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened, was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. Witnesses testified by what they themselves saw or heard or otherwise sensed. They presented direct evidence. Circumstantial evidence is all the testimony exhibits that give you clues about what happened in an indirect way. It consists of all the evidence that is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. It is your duty to decide how much weight to give the direct or circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are any conflicts in the testimony of the different witnesses, you must reconcile them if you can without hastily or rashly concluding that any witness is sworn falsely. The law presumes that all witnesses are truthful. In forming your opinion as to the credibility of a witness, you may look to proof of any, of his or her general character, the evidence of any, for the witness's reputation, the truth, and veracity, the intelligence and respectability of the witness, his or her interest or lack of interest in the outcome of the trial, his or her feelings, his or her apparent fairness or bias, his or her means of knowledge, the reasonableness of his or her statements, his or her appearance and demeanor while testifying, his or her contradictory statements as to material matters, bearing or shown in all the evidence in the case tending to corroborate or contradict him or her. Defendant not testifying. The defendant has not taken the stand to testify as a witness. We shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove her guilt beyond a reasonable doubt. She is not required to take the stand on her own behalf, and her election not to do so cannot be considered for any purpose against her nor can any inference be drawn from such fact. Expert witness. During the trial, you heard testimony of witnesses who were described to us as experts in their respective fields. Rules of evidence provide that a scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence when determining a fact and issue. A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state their opinions concerning such matters and give reasons for their testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. Same as with any other witness, it is up to you to decide whether you believe his testimony and choose to rely upon it. Part of that decision will depend upon your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinion is based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Identity. Court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the alleged crime with which he is charged. In considering the identity of the person, the jury may take into consideration all the facts and circumstances of the case. The court further charges you that if you're satisfied with the whole proof of the case beyond a reasonable doubt that the defendant Shelby Isaac committed the crime charged against her, and you are satisfied beyond a reasonable doubt that she's been identified as the person who committed the crime charge, then it would be your duty to convict her. On the other hand, if you are not satisfied with the identity of the proof, or if you have a reasonable doubt as to whether she's been identified, then the whole body of the proof of the case, then you should return a verdict for not guilty. Confession or admission against interest. Evidence has been introduced in the trial of the state or statements by the defendant made outside the trial to show a confession or admission against interest. A confession is a statement by the defendant that she committed the crime charged. An admission against interest is a statement by the defendant which acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. So determining, consider the circumstances under which the statement was made. Also consider whether any other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given to such statement. If you decide a statement was made, you should consider it with all the other evidence in the case to determine the defendant's guilt or innocence. Accomplice. The accomplice is a person who knowingly, voluntarily, with common intent, the principal offender unites with him or her in the commission of the crime. If a witness was an accomplice in the crime, then his or her testimony must be corroborated. Corroborating evidence is that evidence entirely independent of the accomplice's testimony, which, taken by itself, leads to the inference not only that a crime has been committed, but also that the defendant was implicated in it. This independent corroborative testimony must include some fact or circumstance that affects the defendant's identity. Corroborative evidence may be direct or entirely circumstantial, and it need not be adequate in and of itself to support a conviction. It is sufficient if the corroborative evidence fairly and legitimately tends to connect the defendant to the crime charged. It is a question for the jury to determine whether an accomplice's testimony has been sufficiently corroborated. In this case, it is a question for the jury to determine whether the witness, Victoria C., was an accomplice in this alleged crime. If you find from the proof that the witness was an accomplice, then the defendant cannot be convicted upon the uncorroborated testimony of his witness. If you find that the witness was not an accomplice, witness. Then you will judge the weight to be given to her testimony, just as you do that of any other witness in the case. Unanimous verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Unanimous means agreeing in opinion, being in complete accord, agreement of all the jurors and holding the same opinion. You will use the forms of the following pages to record your verdict. Deliberation, order, consideration. Reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense, or have a reasonable doubt that the defendant is guilty of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or unanimously have a reasonable doubt that the defendant is guilty of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. Multiple counts, finding on each required. The crime charged on each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding against each crime charge must be stated in your verdict. The charged offense count 1 of this indictment is first-degree murder during the perpetration of aggravated robbery, alleged victim Eddie Tate. The lesser included offenses in order of consideration from greatest to least are second-degree murder. The word during is the whole thing explains a lot. Voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict count 1. If you find the defendant guilty of the charged offense count 1 beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of first-degree murder in perpetration of aggravated robbery as charged in the first count of the indictment. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilty of lesser included offenses in order of consideration from greatest to least, as said on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, the verdict should be: we, the jury, find the defendant guilty of blank as included in the first count of the indictment. Servant said blank space and lesser included offense. If you have a reasonable doubt that the defendant is guilty of the offenses charged included in the first count of the indictment, it is your duty to acquit her, and your verdict should be: we, the jury, find the defendant not guilty in the first count of the indictment. You write your verdict as count 1 on the inside of the jacket, sign where your name is the verdict as foreperson. You next consider your verdict in count 2 of the indictment. Charged offense count 2 in this indictment is first-degree murder, alleged victim Eddie Tate. The lesser included offenses in order of consideration from greatest to least are second-degree murder, crossing out the word bearing, voluntary manslaughter, reckless homicide, and criminally negligent homicide. Verdict count 2. If you find the defendant guilty of the charged offense count 2 beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of first-degree murder as charged in the second count of the indictment. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilt of this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, Verdict should be, where the jury found the defendant guilty of blank as included in the second count of the indictment. Asserted said blank space is lesser included offense. If you have a reasonable doubt that the defendant is guilty of the offense charged and included in the second count of the indictment, it is your duty to acquit her, and your verdict should be, we the jury found the defendant not guilty in the second count of the indictment. You will write your verdict is to count 2 on the inside of the jacket, sign with your name as the verdict visible first. You next consider your verdict to count 3 of the indictment. The charge against count 3 of this indictment is first degree murder, alleged victim Edwina Thomas. The lesser included offenses in order of consideration of greatest to least are second degree murder, during voluntary manslaughter, reckless homicide, criminal negligence, homicide. Verdict form count 3. If you find the defendant guilty of the charge against count 3 beyond a reasonable doubt, your verdict should be. We, the jury, find the defendant guilty of first degree murder as charged in the third count of the indictment. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt of her guilty of this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of a lesser included offense beyond a reasonable doubt, the verdict should be, we, the jury, find the defendant guilty of blank as included in the third count of the indictment, certain said blank space, lesser included offense. If you have a reasonable doubt that the defendant is guilty of the offense charged and included in the third count of the indictment, it is your duty to acquit her, and the verdict should be, we, the jury, find the defendant not guilty in the third count of the indictment. You will write your verdict as to count 3 of the indictment on the inside of the jacket and sign one of your names as the verdict is foreperson. You will next consider your verdict to count 4 of the indictment. Alleged offense count. I should say 4. This indictment is first degree murder, alleged victim, the unborn child of Edwina Thomas. This indictment is first degree murder, alleged victim, the unborn child of Edwina Thomas. The lesser included offenses in order of consideration of greatest to least are second degree murder, voluntary manslaughter, reckless homicide, criminally negligent homicide. Verdict form count 4. If you find the defendant guilty of the charged offense count 4 beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of first degree murder as charged in fourth count of the indictment. If you unanimously find the defendant not guilty of this offense or have a reasonable doubt for guilt of this offense, you will next consider her guilt of lesser included offenses in order of their consideration from greatest to least as set out on the previous page. If you unanimously find the defendant guilty of the lesser included offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in the fourth count of the indictment. Asserted said blank space, lesser included offense. If you have a reasonable doubt that the defendant is guilty of the offense is charged and included in the fourth count of the indictment, it is your duty to acquit her, and your verdict should be, we, the jury, find the defendant not guilty of the fourth count of the indictment. You will write your verdict as to count 4 on the indictment on the inside of the jacket and sign one of your names and verdict is foreperson. Now, rather than divide up the closing arguments, because it's 12 o'clock. I think the lunch might be here. We'll have to do the closing arguments right after lunch. I think. If it's not here, we'll do the first closing and then we'll break the lunch. I think Mr. Hager went downstairs to get the lunch with the jury. We all prefer to do all closings after lunch. Oh, okay. Yes. All right. Well, Mr. Hager has your lunch, so what we'll do is, as far as the trial is concerned, ladies and gentlemen, still can't discuss it. Okay. Leave your notepads there, and we'll bring you back in after you leave. Okay. Okay, I would like to maybe call my docket.
Judge, we actually have to, we have to address the verdict forms. If you want to consult, starting at page 25, Judge, of your instructions that you just read the jury, that's the first verdict count 1 form. State believes that to be accurate. However, count 2, Judge, the verdict form says the alleged victim of count 2 is Edwina Thomas. That is the opposite of your Honor's earlier instruction and indictment. Edwina Thomas is actually a victim in count 3.
That's true, you're right.
And the count 4 should be the unborn child. Eddie Tate is the victim in both count 1 and count 2. Murder and the murder of Eddie Tate, the perpetration of aggravated robbery being count 1. Premeditated murder of Eddie Tate being count 2. Count 3 being premeditated murder of Edwina Thomas. Count 4 being the unborn fetus. Where it appears that the count 4, Your Honor, just read to the jury is just a general premeditated murder, and we did not include the premeditated killing of Eddie Tate in the verdict form section. But Your Honor did include it in the earlier portion of the jury.
Okay, count 1, Eddie Tate is murder first.
Yes, Judge.
That was right.
Correct.
And going to page 26, and then 26 is murder first degree for Eddie Tate.
My page 26 begins with the charge offense in count 2 of this indictment of first degree murder alleged victim Eddie Tate.
That's correct.
Okay, that's correct.
All right. The only problem I had is having the word during in there.
Right, starting on page 27.
27.
All right, Judge, it appears to be correct.
Yeah. Okay, now 28 is count 3, and that's victim at William Thomas. That's correct, right?
All right.
And then
I think the confusion,
the only thing I saw a typo on page 30.
That's
Repeated count 3 is supposed to, I scratched it out, I filled the jury score.
all right. Thank you, Judge. I just noticed that when Your Honor was reading it and wanted to be absolutely certain.
So I'm always open to be corrected if I hate for them to get the wrong thing. Just wish one of us had noticed when we read over there that the extra word during was in there on the end of murder second degree, because it's not during anything. It's murder second degree. But now the jury verdict forms are correct. Second degree voluntary manslaughter.
And Your Honor did instruct him on page 30 that that should be 4, and you marked it on the original. That would be back.
Right, it's on the original.
Thank you,
I
Judge.
told them that had to be. But I think it's right.
Thank you, Judge.
I'm glad you second me. Now, I'd like to at least call my docket, because I hadn't called it all week, and maybe we can do that. Let's count on about 1:30 for the closing argument. Okay? Okay. Now let's take a recess so we get the